So I wanted to talk today about actually the last trial I had before the courts shut down for the COVID-19 emergency. It was an OUI marijuana case in Massachusetts, and it was actually the first time I had tried that particular type of charge to a jury. In the past, and I've had many OUI drug cases in Massachusetts and New Hampshire, but especially with the marijuana cases and impaired by drugs, whether they be prescription or illicit drugs, I've almost always opted, in my memory, for a bench trial, because usually a judge is well suited to hear the evidence and make the legal decisions that need to be made in these types of cases. I had recently a case, it was an OUI marijuana case, where I was not all that familiar with a particular judge. I did pick a jury, and I argued the case and tried the case to a jury of 6 in Massachusetts. What's interesting about these OUI marijuana cases is that the government is very limited in their ability to present evidence regarding an opinion about impairment, meaning a police officer is not able to take the stand and testify that he formed an opinion that a particular driver or my driver was impaired by marijuana. The officers can testify about what they saw, what they smelled, what they observed, but they cannot, because they are not qualified either as medical experts or toxicologists or pharmacologists, to state an opinion that a person is actually impaired by the marijuana that they have consumed, even if they've admitted consuming it. And a big part of that, number one, is marijuana. The use and possession of it is not a crime in the Commonwealth anymore, and it's been that way for several years. But recent decisions by the Massachusetts Supreme Court, especially the Gerhardt decision, limit the ability of the police to testify regarding opinions of impairment. And field sobriety testing is designed to elicit information about impairment by alcohol. Those tests were not designed to elicit information about impairment by any other substance other than alcohol. So although the police can ask a person to submit to the standard walk and turn, one-leg stand, finger to nose, those types of physical activities roadside, they're not allowed to state that based on those tests and the driver's performance that a particular person was impaired by marijuana. And then finally, most importantly, the jury instructions that are now in place in Massachusetts are very helpful for the defense, and they help out quite a bit. So if you're facing an OUI marijuana charge in a Massachusetts courtroom, it is incredibly important to have an attorney that is familiar with the latest in the law that applies to these particular cases, and a lawyer that is capable of trying these types of cases to a jury. And as I said to the jury in this case recently, we're not where we were 10 years ago. Marijuana use and possession is not a crime, and the government still has the burden to prove beyond a reasonable doubt that a person is impaired by what is now a legal substance. So please keep that in mind. If you have a friend or family member who's facing one of these charges, hire a trial lawyer, not a plea escort service.